Okay. Well, we are now broadcasting. Welcome to Religious Freedom Implications of the COVID-19 pandemic. I think we're all here remotely and glad you're here. A recent Atlantic article reported that Americans largely agree on the need to temporarily forego their constitutional rights in the interest of fighting the COVID-19 pandemic. I'm trying to read and look at the screen at the same time. Christianity Today cites an American Enterprise Institute survey that 72% of Americans don't think there should be religious exemptions to the emergency public health orders in place in some 45 states. But of course, that means that there are a sizable number of dissenters, a minority who reject such restrictions. We're going to look into that and also the CARES Act, issues of funding of religion, a number of very significant constitutional issues that have arisen. Now, you've all registered for the program, so presumably you've seen the lineup of distinguished presenters. I have asked each panelist to briefly introduce themselves when they first begin speaking. So let me begin. I'm your moderator, Alan Reinach. I serve on the Religious Liberty Committee of the Civil Rights and Social Justice section of the American Bar Association. My day job is Executive Director and General Counsel of the Church State Council, a Seventh-day Adventist organization based in Southern California. Now, during today's program, we encourage you to ask questions of our panelists. As an attendee, you should see a control panel with controls such as audio options, chat, raise hand, and Q&A. For purposes of this webinar, please submit your questions through the Q&A, not the chat function. If you don't see these controls, please ensure your screen is not idle. And we're going to address questions at the end. We will also be sharing a recording of this program to all who have registered so that you can share it widely with your network, so please do. And please feel free to leave feedback or ask questions to follow up. Now, we're going to start by hearing from the chair of our committee, Richard Fulton. Richard, congregations have First Amendment rights to assemble and to worship, but these rights are being restricted by a variety of state and local ordinances, I think in 45 states at last count. Can you start us with kind of a brief overview of the constitutional analysis? How do we analyze these types of restrictions in their constitutional framework?
Sure, Alan. Thanks very much, and thanks to the Civil Rights and Social Justice section for organizing this important program. And as Alan mentioned, I am the co-chair of the Religious Freedom Committee of that section. I also am a senior scholar for religious freedom at the Religious Freedom Center of the Freedom Forum, which I used to identify by saying it was at the museum. The museum is sadly closed now. That was the Museum of the Press on Pennsylvania Avenue, but happily the Freedom Forum continues to do its important work in new office space. In addition, for many years, I was a senior staffer at the American Jewish Committee, during which time I did work on religious freedom issues with a lot of focus on the intersection of religious freedom and other important interests, including workplace religious accommodation. This subject is one that's near and dear to my heart, namely, how do we ensure that religious liberties are protected at the same time as giving due regard to the other constitutional concerns, or in this case, the public health concerns that we need to protect as well. I think it's fair to say that today's program is, being as it is, part of a series that the section of Civil Rights and Social Justice is doing on the impact of COVID-19, of the pandemic, on a variety of constitutional rights and other public policy concerns. It's right and proper that we treat religious liberty as fully a constitutional concern as any of these other rights, whether it be assembly or speech, the press, etc. And that's not to say that religious liberty rights don't have to give way to some extent under the circumstance we're living in. But it also is to say that when we do so, we need to do so with great care, with great attention, and to be sure that we're not constricting religious liberty and the right of folks to worship and to exercise their religion any more than we absolutely have to. And in fact, we are dealing in a situation where there are reasonable and even compelling reasons to limit religious activities under these circumstances. So we have to be clear what the standards are that we're applying, so that we're clear as to what should be limited, and therefore also clear as to when we can turn the switch back on and folks can go back to exercising their religious liberty in the way that they had been used to do until now. So I'm very glad this is the very first question that we're opening with. So the issue has been for a while, how are we to understand that when the government either prescribes an activity or requires an activity that would cause an individual or a community or institution not to be able to act in accord with its religious beliefs. And for a long time, that standard was understood to be what we call strict scrutiny. That is, your religious liberty interests couldn't be constrained unless there was compelling state interest, and it couldn't be met by more narrowly tailored means. There was a case a while back, the Smith case, which basically held that's not necessarily the case, that in fact these religious rights can be constrained as long as there's a reasonable basis to do so, which translates into as long as religion is not being discriminated against or singled out, but there's a reasonable basis for the government to act, in which case your religious liberties can be constrained. And the question is, which are we operating under any given time? And it's not clear. It's not clear. It may be that this reasonable basis regime is the one that applies, in which case all the government has to do is say it's reasonable for us to require you not to be able to meet at your house of worship, and that's the end of the inquiry. Or it could be that under some state laws, or even depending upon the facts of the case, that the more strict, what we call strict scrutiny is applying, in which case there has to be a compelling interest that can't be met by more narrow means. I would say that even if you're applying what we call strict scrutiny, it certainly seems as if, in general, the prohibition on large gatherings to engage in worship is something that can and should be prohibited on the same basis as other large gatherings are now being prohibited. And why is that? Because it's really hard to think of a more compelling state interest than preventing the further spread of COVID-19. And there's no way to do it more narrowly, because every single person that goes into a large gathering and becomes infected and then goes out and infects other people is an additional danger to the public health. So there's no way to say, well, we'll let some churches have these large gatherings and others not. But as I said, the question is going to be, so in which case it means that the standard we're applying isn't as important as it might seem, because in fact, under any of these standards, by and large, we're going to want to uphold the right of the government to apply. So that's I think a good basis to at least start the conversation on, so that we understand what the rules of the game are when the government is considering preventing houses of worship from opening for business as usual.
Thank you, Richard. So we're going to drill down a little bit deeper. I've asked our next presenter, Maggie Garrett, to take a look at the different types of restrictions, which may very well need to be analyzed separately. And I have in particular mind that a Kentucky church obtained a temporary restraining order over the weekend to permit it to conduct a drive-in Easter service. Maggie Garrett, would you talk about the different types of restrictions and if you want to, how they might apply to these drive-in services?
Sure. So I'm Maggie Garrett. I am the VP of Public Policy at Americans United for Separation of Church and State. I've been at Americans United for about 13 years. Before that, I was a litigator and the lobbyist at the ACLU of Georgia, and before that, the ACLU of Alabama, working on church-state issues for a long time. In fact, actually, my first fellowship was at Americans United in the year 2000. So I started out there and came back. So shows that I I really like working there. So as Richard and Alan alluded to, governors and state health departments are issuing executive orders that are designed to require people to engage in social distancing as a way to protect the public health. Some local governments are also issuing ordinances to do the same. And there's been confusion about which states have which religious exemptions, how they apply, and how they all work together. Not all of them are clear. Every state is different. But at AU, we've been looking at the orders as having 3 levels of restrictions. First, they have the big limits on mass gatherings. So that's sort of at the top. This is where we're focused. And following recommendations from the CDC that explain mass gatherings could lead to the spread of the virus, states have been limiting the size of gatherings. They started saying no more than 500 people. They lowered them to 250 people, then 100 people, then 10 people. Now some states even have limits of 5 people. 35 states in DC have bans on mass gatherings with no religious exemptions. And then there's 6 states that have bans on mass gatherings with the religious exemption. Some states still have no mass gathering bans at all, and others aren't clearly written enough to figure out where they belong on this chart. And we have a great concern about the mass gathering exemptions. We argue, as Richard does, they're not required by the free exercise clause. Most of them are neutral and generally applicable. They serve a compelling interest. We go as far as saying that they're actually prohibited from having exemptions under the Establishment Clause. If you say there's no mass gatherings, but you can have religious gatherings, that gives a preference to religion over secular gatherings. Also, the Establishment Clause has a line of cases saying that you can't grant religious exemptions when they harm other people. We think that it's clearly a harm if you are spreading the virus to people who aren't even going to your services. The second level we see are the non-essential businesses orders. So what these do is they shut down all non-essential businesses, and then they include a list of essential businesses that are allowed to remain open. These include things like hospitals, daycare centers for healthcare workers, supermarkets, pharmacies. These all vary state to state. Some allow liquor stores to remain open, others gun stores, other landscaping businesses, but most states allow houses of worship to remain open. This makes sense so that they can perform funerals, they can actually turn on the live stream cameras or have the clergy person at the house of worship. Some EOs are vague, but most can be read to maintain the mass gathering restriction. So they can be open, but they still can't have mass gatherings. Then we have the stay-at-home orders. These are the ones, many of you might be in states that say you can't leave your house unless you're going to an essential business, like the hospital, the pharmacy, the liquor store, walk your dog. I can't recall seeing any executive orders that didn't include houses of worship in here. Again, you can't perform a funeral even for a few people or have a live service if you can't get to the church or house of worship. And usually these don't trump the mass gathering restrictions. And then of course we have the much lower level, so that's on the state level, and then some local governments are also having their own ordinances. Some of the states are prohibiting the local governments from going further, some are not, and that's where the Kentucky order comes in, where the question is, can you have a mass gathering if you all stay in your car in a parking lot? And the facts in that case, which we may go into a little bit later, are kind of confusing because you don't really know what the governor said, what the mayor said. Are they enforcing this? Are they not enforcing it? And so some of these, again, I think it's people working in an emergency situation in an unusual area of the law. And so there is definitely some confusion.
Thank you very much. I'm going to ask Mark Chopko, our next presenter, to do a couple of things. Mark, first, I know you represented, or maybe still do to some extent, the Catholic bishops for many years. If you could address how the Roman Catholic community has been adapting to the restrictions, but also I think Maggie's discussion raises issues of inclusiveness. And I've been hearing a lot of complaints from clergy. Well, how is it that liquor stores are considered essential services but not churches? And they're raising questions about how inclusive or exclusive these lists of essential services are. So I'm wondering if you see a problem with how these are being drawn. Do you agree with Americans United that there are Establishment Clause problems with exemptions for churches? I know I've asked you a bunch of questions here, but give it your best shot.
Well, thanks, Alan. That means I can answer any one or none. So thank you for that. I'm Mark Chopko. I am the chair of the Religious and Nonprofit Practice Group in the Washington, D.C. office of my law firm, Stradley, Ronan, Stevens & Young. We represent a variety of religious organizations around the United States and even some in Western Europe and the Pacific Rim that do business in the United States. And as part of this, we've been really actively involved with our clients, trying to help them navigate these new waters. Part of my work has always been in the area of religious liberty. I'm a litigator by trade and have been involved in a lot of church-state disputes, some of which have made some of the law that we're going to talk about today. And I was involved in the final drafting of the Religious Freedom Restoration Act with others in the religious community and civil liberties community at the time. So the first question Alan asked me was about my own community and how my own community, which is the largest in the United States, has adapted to all of this. And I think that it's been a struggle. People have been trying to figure out how they can adapt themselves and adapt their own practices to the restrictions that are necessary to preserve public health. The former chair of the Religious Liberty Committee of the Bishops' Conference, Archbishop William Lori of Baltimore, was in a press statement and I think a little video clip a couple of days ago where he said that we all understand that these restrictions are necessary for the protection of the public health. At the same time, communities have tried to adapt themselves to this. My own parish, for example, posted a video about how people could go to confession and had positioned chairs throughout the sanctuary so that they were 6 to 8 feet apart. And you could sort of move through the sanctuary to the room where confession, the sacrament of penance, was going to be administered, and maintain a proper safe distance away from the other people in the sanctuary area and even from the confessor. So this is a creative way in which the sacraments are being administered, and they're also using the media to broadcast this to the community. Another one of my pastor friends who's no longer has daily mass for the public does have a daily mass that he posts on his church's page along with a 2-minute reflection on the scriptures so that people who want resources can find them. And so it's an adaptation, and it's the use of technology to try to reach people. It's not the same. The community has value in the Catholic community, and the community gathering together has value and is part of the way in which the church worships. But I think that people are trying to do the best that they can. To the extent that I've been able to tell, Catholic houses of worship are open for private prayer, even if they're not available for communal worship. But again, the expectation would be that people take steps to protect each other. They maintain proper social distance, and they try to show respect for other congregants. At the same time, it's to move to your next question, Alan, some of these adjustments have caused confusion. And I think that some of the situation here, especially in the states that have tried to explain what they've decided to open and what they've decided to close, have engaged in poor optics, but sometimes even poor substance if they're extending the restrictions to private prayer and private reflection in different spaces. So I don't know that this is going to be an ideal answer, but at least to some of the questions that I've seen, some of the emergency measures that have called churches not essential services, again, probably need a better PR explanation. And if they're in states where they have state religious freedom laws, then they have to be able to explain why these are justified for public health reasons. And frankly, given the epidemiological facts, I think that there's a good case to be made for why these are going to be subject to a public health restriction. The same way that the historic vaccination cases and quarantine cases 100 years ago were able to be established over religious objections. So I'm going to, I'll leave you with this point, Alan, is that I think that the point here is to approach religious exercises on equal terms with other communities. That so long as they're not being singled out, you know, from one direction or the other, you don't even engage the constitutional question. I don't share the conviction that allowing religious organizations to worship in all circumstances is a violation of the Establishment Clause, and I don't share the rationale that that the Establishment Clause accommodations are purchased only so long as you can't articulate a burden to anybody else. But that's not the purpose of this webinar. So I'm going to stay out of that thicket, and we probably all ought to stay out of that thicket, or we won't get to these other important questions. So back to you, Alan.
Fair enough, but you know, Maggie was very articulate and in expressing a viewpoint, and I figured there was probably some disagreement on the panel, so it helps to give our attendees a broader perspective of, and that's why we have a diverse panel in the first place. So, Rama,
I'll be glad to get into a thicket in a moment.
Okay, I'm going to turn to you.
No, you won't.
We're going to go to our next panelist, Rama Abdul Alim. How have these restrictions impacted the Islamic community?
Thank you, Alan. My name is Rama Abdul Alim, and I'm the Executive Director of Karama, Muslim Women Lawyers for Human Rights. We educate and advocate on women's rights, domestic violence, human rights, and religious freedom. And so we have been really active in this space right now. It's become a burning issue. But for Muslims, it's one of probably the big distinctions between some of the other communities is that a lot of our communal worship means a lot of face-to-face interaction, touching of other people. And so it's really not possible for us to in any way change our communal prayer to actually be feasible for people to do separately. And I'll use as an example, we have prayer 5 times a day, and there's one prayer that's in the mid-afternoon. And so most of the time outside of COVID-19, the masjid, or used to be called mosque, but mosque is the French word, Muslims use masjid. The masjid would be open for all the prayers. So if you enter the prayer space and there's someone else praying, you would go up and stand right next to them toe to toe and pray with them shoulder to shoulder. You wouldn't necessarily keep the 6 feet away. So Muslims have really had to just cold turkey close our religious organizations, our religious spaces, because otherwise we would really be just kind of a really epicenter of transmitting COVID-19, because we really can't realistically change the way we worship in order to be 6 feet away. So we don't have anything that is equivalent to confession that Mark talked about. Everything we do is kind of so jointly that most of our organizations, and I really haven't heard of any masjid that has really stayed open to the point where it's open for the imam to give lectures that are live streamed or zoomed or whatever they're done. But some have stayed open to say their food bank has stayed open, or if they're attached to some kind of shelter or something, those things have stayed open. But for worship themselves, we have really had to really go cold turkey and close it completely, just because of the way our worship services work.
Well, these are surely extraordinary times that we're dealing with and have impacted all of our faith communities. Been very difficult to adapt. Richard, it was back to you now. It was Passover last week, and just as Christians really had to adapt in how we addressed Easter, I'm sure there were a lot of different approaches to Passover Seders and all. But talk about that for a moment, but then do go back to the constitutional issues that Maggie raised. I know you wanted to speak to those.
So yes, it has been, on the first night of Passover, the question, the second night as well, if you live in the diaspora.
Why is this night different from all other
nights?
nights?
So why is the Seder different from all other Seders? And it definitely was a very different Seder. It's basically the nuclear family. And for those, there's Jewish law questions as to whether or not you can have a Zoom presence of others at your Seder, whether you're allowed to use electronics and computers. For a great many Jews, they use them, and the way they were able to do the Seder is to have everybody with their own little Seder plate, and perhaps we'll have one person leading the Seder, as is usually the case. But it's all being done by Zoom, just as we're meeting now by Zoom. And that was the way that we're able to have, many Jews were able to have their Seder and still feel involved and with family, even though in fact they couldn't be with family in the same way that they ordinarily would be. For some, that can't be done because they live under, they're Orthodox and they're living with more strict rules, and then it's just the 2 or 3 people that might be in the home making a Seder for themselves. In some case, people just making Seder for themselves. And we're reminded that Natan Sharansky, when he was a prisoner in the Soviet Union, a refusnik, would make Seder for himself in the prison. So I don't think we should compare anybody who's free and living in the world, even in this current world, to the situation that Sharansky was in. But nevertheless, it's not without precedent that Seders have always been made in exigent circumstances, that were made during the Spanish Inquisition and when Jews were living under the shadow of the Holocaust and after the Holocaust, and still this was a centerpiece of Jewish observance and remains so under current circumstances. That certainly has been the case, that those observances have been constricted and modified and changed from what we're all used to and what we very much long for in the next year. Worship services also. The traditional Jewish congregation, depending if it's Orthodox, in which case 10 men have to be present. If it's an egalitarian congregation, 10 people. But in either case, there's essential parts of the service that you really can't do without a quorum of 10. And that includes reading from the Torah on Shabbat morning or on holiday mornings, as we always do. And I would say 99.9% of Jewish congregations, both in the United States and around the world, have said, we have to give that up. There's a concept in Judaism of pekuach nefesh, preserving life, and that comes ahead of everything else. And if that means that to preserve life, we can't have a service with a quorum, and if that means we can't read from the Torah for what's going on 4 weeks now, so be it. But the preserving of life is more important, and we all pray for the day when we'll be back together and serve. And there's some, in the Reform movement and others, there's some that are willing to have virtual quorums and proceed on that basis, to have 10 people gathered around the computer. But that's not, for those that are willing to do that, fine. That's great that they're able to do that. But I think the key point is that whatever the law says, before there was any restriction in Maryland, our rabbi closed down the synagogue. And we've had, none of that has prevented him giving talks. I mean, talks don't take place on Shabbat because he's not going to use the computer. But we're hearing, words of Torah, and we're convening, and we're doing other things that are normal to the life of the synagogue. We're just not doing it face to face under these circumstances. And that's true for the most part. I say for the most part because, and it's in the papers, both with respect to Jews and Christians, and I think even some Muslims, that there's been some defiance, some scofflaws that are out there that are saying, no, it's as we've spoken about before. They're saying it's an infringement on our religious liberties. The worship doesn't mean the same thing if we're not together in person, and we're going to go ahead and do this anyway. And and that's even in the face of their own leadership. I think of the ultra-Orthodox community, where a lot of this scofflawism is going on when it takes place. And by no means do all ultra-Orthodox Jews doing this. There are many that are doing the appropriate thing and keeping separate and not congregating. But for those that are doing it, they're often doing it in defiance of their own leadership, who say to them, no, you really ought not to be convening for in large numbers for funerals, etc. So it's a mixed bag in terms of how to accommodate and how to adapt, and it's a mixed bag even in terms of observance. But again, I think it's fair to say that the vast majority of members of the Jewish community are complying with the restrictions that have been placed on them and are acting in a fashion that's appropriate, both to to guard public health and the safety of their own families, and at the same time find a basis for spiritual solace and spiritual contact. Nevertheless, even though obviously it's not the same thing as we're used to. Just a couple of words on the constitutional issues. I don't think I agree with Mark, who I think began to say that it can't be the case that the test for appropriate accommodation is no harm whatsoever to anyone else. There can't be an accommodation that has no impact on the third party whatsoever. It just logically doesn't make any sense. The question, I think, and this goes back to an old Supreme Court case, Thornton against Calder, I think the test is going to be, is there material harm? And again, that's one reason why this is no place to talk about religious accommodations, exemptions, because obviously there is a material harm that will come out of an accommodation, and therefore you can't require it. But I just think it goes too far to say you can't have any impact on third parties and still be entitled to an accommodation. At some point, there has to be some kind of impact that's not a harm that's cognizable, but nevertheless people feel an impact of that accommodation. That's not this case. That's clearly not this case. I'm not talking about this case. The other point I just want to make is, on the issue of essential businesses and all of that, there's an important principle which has come up in other kinds of cases, and let me just name one, where the question was whether or not prisoners were entitled to wear a beard for religious reasons, where prisoners who for medical reasons had to grow a beard were being allowed to do so. And the courts have said, if you're going to be granting a secular exemption, even though there's a good reason for it, you can't treat religion as less important. That is, the fact that religion is not a quote unquote physical need that's required by medicine or like food or such things, doesn't mean that it isn't something that's incredibly important and that doesn't need to be, and it's a need that has to be respected at least as much as we respect these other secular concerns. So I think with all of these issues with what the states are doing and the local governments are doing, we have to really drill down in each case as to whether in some way they're treating religious interests as somehow being less important than other secular interests, such as, for instance, allowing gun shops and liquor stores to be open as essential businesses. And I have nothing against liquor stores being open as essential businesses. I know that would make Mark very unhappy, but I do think that if you're going to allow those to be open, it would make me unhappy also. But if you're going to allow those businesses to be open as essential, then there's no less reason to treat religious institutions as essential, but they have to be subject to the same prescriptions on mass gatherings as everybody else. And therefore they can be open for those limited purposes with social distancing, with a limited number of people on the premises that will allow them to go about their business. Now, that doesn't mean they have to do that. And we've heard from Ramah about how doing that doesn't make sense from the perspective of the Muslim community. I have to say, in my own synagogue, our rabbi when he talks to us over Zoom, he's got a nice virtual image of the sanctuary, of one of those virtual backgrounds you can set up on Zoom. So he doesn't need to go into the synagogue to have that background. So I don't know that he's been in the physical synagogue itself more than a couple of times since all of this started. And that's fine. But for those that need to go there, I think it's when they treat it an essential business to the extent other essential businesses are being allowed.
So we're going to turn to Maggie Garrett next, because there have been already conflicts, court cases filed. Some of the churches that are challenging the restrictions clearly are defiant and not being careful with social distancing, but others are, Richard, they're insisting that, yeah, we're doing all the precautions that you would expect of your grocery store or your Costco or anywhere else, and why are we not allowed to do that? And so they are very much raising some First Amendment concerns with varying degrees of success. So Maggie, I know Americans United has been monitoring a number of these cases, and it's a moving target, but give us a quick overview of what's been going on in the courts.
Sure. So far we've seen lawsuits in 6 states: New Hampshire, Texas, Virginia, New York, Kentucky, and Kansas. In New Hampshire, New York, and Virginia, plaintiffs challenged the state's limit on mass gatherings in state court, claiming, among many other things, that the orders violated their religious freedom because they couldn't attend church services or other religious services. In all 3 cases, the state courts ruled against them. Only one of the 3 cases in New Hampshire was there a written opinion, and there was no state RFRA or a stronger state constitutional provision. So this was under just the question was whether it was neutral and generally applicable, and the court ruled that it applied to houses of worship just like everyone else, and so explained that there was no religious freedom claim. There are 2 remaining cases in Virginia in federal court as well. In Texas today, there were arguments that were held. In that case, they were challenging a county mass gathering limitation. And in that case, they really seem to be, I think, going over, really trying hard to accommodate religious gatherings. And they said, if you can stream your service, you must stream your service. If you can't stream your service, then you can meet in person. But if you can stream your service, you can't meet in person. And there were plaintiffs today. They filed suit. There were arguments, and they said, no, it restricts our religious liberty for us to not be able to gather in person, even if we can gather via the internet. So that case, I didn't listen to the arguments today. I think that was argued around 11 o'clock today, so we'll be hearing an opinion in that soon. And then on Saturday, 2 court opinions were issued, one in Kansas, one in Kentucky. In Kansas, the case itself actually isn't over a religious freedom issue. In that case, the governor originally issued a mass gathering ban that excluded houses of worship. Then last week, she held a press conference noting that 25% of the COVID-19 clusters in Kansas were connected to churches, and therefore with Easter coming and expecting a lot of mass gatherings, she felt she had to extend the ban to houses of worship. The next day, a legislative committee, not the entire legislature, but there was a committee that had been created to examine executive orders that the governor put out in Kansas and perhaps overrule them if they wanted. The attorney general said that her executive order was unconstitutional. The committee met, they had a little hearing, they overturned her executive order, and then she challenged it, saying that they didn't have the ability to do that under Kansas law. So she ended up winning. There was a actually kind of fascinating Zoom hearing, Kansas Supreme Court hearing, where you got to see all of the judges' offices and living rooms, which was kind of exciting. They all wore their robes. It was a great argument. There were like 4,000 people watching it. And they ruled in the governor's favor, but it was not on the religion issue. And then in Kentucky, this was the drive-through churches issue. And the issue was, whether they had to ban drive-in churches. And, some people did argue that they're in their cars and they're not, that there is no real threat there. Some people argued that, well, the people are getting out of their cars, they're not really staying in their cars, people are going in to use the bathroom, it ends up being a lot more people. The judge in that case thought that the ban was targeted at churches and uneven, and ruled in favor of the church and allowed them to gather on Easter. A lot of these are also really coming down to, at this point, political arguments. So in Louisiana, there's a pastor who just continued to meet. And so the judge said that, or the governor said he was going to go to the service and take down license plates and require that those people then quarantine for 14 days, as would be required of anyone who was at mass gatherings. Some people then covered their license plates so that the police couldn't gather them. I'm not quite sure what's happened since then. I haven't read as much as I thought I would read on Twitter about that, but a lot of it has not maybe made it to court, but there's a lot of political fights going on about what the governors and the local organizations can do.
Well, and my own view is that this is not the time for us to be standing on our rights. This is the time for us as the faith community to be modeling protecting people's lives. but of course, not everybody agrees with me. Mark, I'm going to turn to you for a moment. I know you've done a lot of work defending lawsuits against religious bodies as a litigator. Are there circumstances where you would be concerned about congregations incurring civil liability if people attended, a church service or a synagogue or whatever and died after their attendance? And would it matter if they were seeking to follow social distancing, et cetera? What are some of the issues there? And I guess a corollary of that is whether congregations are at risk of losing their insurance coverage. I understand there was a report, one of the churches that have been in the news in a conflict, it was reported that their insurance carrier pulled out.
Interesting. Thanks, Alan. I'll give you a very lawyerly answer. It depends.
Right.
And you yourself suggested that the facts and the circumstances matter. So let's see if we can pick this apart. Apart from COVID, lawsuits that have challenged bad things that happen inside church communities during the course of a service. For example, an altar call where someone is slain in the spirit, falls on the steps, hits her head, claims a premises liability claim. Some people who have filed lawsuits over conversion experiences, over exorcisms or other spiritual interventions. People who have filed lawsuits alleging that the pastor defamed them on a sermon. All of these lawsuits, by and large, have in the past been rejected on First Amendment grounds, on the grounds that in order to sustain a tort case on these bases, you'd have to figure out what would a reasonable religious community be doing in those sets of circumstances. We're in a different set of circumstances now. And so this is another area where I think it depends. If the churches are open, and people are urged to practice social distancing, as we see in the variety of circumstances, if somebody alleges that maybe the church wasn't clean, or there was some other issue that they encountered the COVID virus in the house of worship, I think those cases are going to follow a steep path towards recovery. But you could also imagine a set of circumstances where a church meets in violation of the law, and that the law bans mass gatherings on the specific grounds that we're trying to prevent contagion. In those circumstances, it's possible, I haven't thought it all the way through, it's possible that someone not only would be able to have their claim sustained as a cause of action, but there may even be negligence per se, which gets you over the first two hurdles, because the church is operating in contravention of law specifically directed at preventing that harm. I'm not aware that there have been any cases on this basis yet, but I also haven't looked. So I think that's we're going to see how this plays out. On the insurance part of this, it would be interested actually to see a little bit more about the case where a carrier has decided to pull out, since insurance law is contract law. And I guess if the insurer is saying that their insured has breached the contract by engaging in some illegal practice, or has already declined coverage because the church is operating in contravention of the civil law, and maybe that it's the loss of coverage as opposed to prospectively as opposed to retrospectively. But usually in these circumstances, for example, in the other cases that I talked about, somebody goes to church and claims that they got sick in church, even though they followed all the rules and followed all the precautions, and that maybe the church shouldn't have been open at all. And shame on them for doing that. I would think that that's not a situation where you're going to lose your insurance, and that's one where the carrier is going to have to defend unless it's excluded under some other clause of the insurance contract. But like all contracts, you have to read the fine print.
Fair enough. Well, I do know that making sure that you can keep your insurance coverage is a very important issue for denominations and congregations alike. Well, we've taken a long time on these issues so far, but we're going to shift our focus now to the CARES Act. Congress has included churches broadly in the Paycheck Protection Program, for one, to soften the economic blows of the pandemic. Such direct aid to religion surely raises important Establishment Clause concerns. Should religious bodies be eligible to receive this kind of direct aid financial assistance? So, Mark, actually, we're going to start with you. If you can give us the overview of the key economic assistance programs, and I know there's quite a few. See how brief we can just give it a rundown for our participants.
I promise not to use all the rest of your time. There are a number of these programs. Obviously, the Families First Corona Relief Act provided for unemployment benefits and provided that if people had lost their jobs, they could apply for unemployment benefits. And there were even mechanisms where entities that are normally exempt from the application of federal or state unemployment systems could participate through some means or another. And there are 4 or 5 different mechanisms, but the issue is that people who are employed by churches, which are exempt from federal and state unemployment laws for the most part, can still apply for unemployment assistance under one of the 4 or 5 different mechanisms. CARES came about a week later, and CARES did a number of things that I'll just highlight. There's the Payroll Paycheck Protection Plan, which I'll come back to, the Economic Injury Disaster Loans, which I'll say a word about. But it also increased the charitable giving deduction, a $300 individual deduction above the line. Not clear that that's going to move the needle on big charitable giving, but certainly for people who are in the middle, who are middle income, who are looking for ways in which they can provide charitable relief, it works against the tax reform in the Trump administration and allows a little bit more relief, a little bit more itemization, and smaller charities, just like smaller givers, are going to benefit from that. And then there are also significant appropriations for schools and things like that. So let me hit the 2 big relief programs just in brief. The Economic Injury Disaster Loan applies to private foundations, private nonprofits like foundations and endowments. It covers payroll, sick leave, mortgages, rent, and so on. It provides a rapid advance of $10,000 in 3 days with no repayment. And it looks at credit score to approve. Not clear that about the collateral requirements for that, but there is a maximum 3.75 interest and a 30-year repayment. For community serving nonprofits, some of whom are private foundations, even though they're associated with larger religious bodies or smaller religious bodies, this would provide some form of relief. But the big one that you alluded to, of course, is the Payroll Protection Plan. And again, let me give you just the high points of this. It covers payroll, mortgage, rent, operating expenses, utility costs. It's not dependent on your credit score, but it does turn on proof of what those costs are. Some of the payroll costs are 100% forgivable, but then there are specific things that you must do in order to do that. For example, retaining your workforce at current levels through June 30. It's administered through banks, through an SBA program, and you can apply online. A number of the larger entities have been both in and out of the market, and I think are back in the market again. But for example, Wells Fargo, which does lots of work, was in, then they were out. Now I think they're back in. The repayment is 1% interest over 2 years, and it's open to all 501c3s, both public and private. The statute initially appeared to exclude religious organizations and applied affiliation rules to nonprofits, which would have aggregated some of the charitable communities under what would be called common management to exclude them. The SBA over not this past weekend, but the weekend before, published interim guidance and frequently asked questions that clarified that religious organizations can apply, that the affiliation rules will not apply to those organizations that would only be affiliated through the operation of religious principle. For example, it would be quite common in the Catholic community, since the bishop appoints the pastor, to run afoul of the affiliation rules between a diocese, parishes, and other entities where the bishop retains the right, because of religious law, to appoint the chief operating officer for that local religious charity. But the SBA has decided that what they want to do is expand the footprint for economic relief in the community, and have decided to give religious affiliations claiming RFRA and Hobby Lobby and some other case law as authority. But the point here is that religious organizations can participate on equal terms with secular entities, and that sets the groundwork, at least for relief to flow to a broader group of community serving activities that need it.
Well, I appreciate that overview. Certainly all of the details of how these programs work are the subject of a different webinar. I've attended some of those that go on for quite some time because they're rather detailed and raise different issues. But for our purposes, one of the questions is whether this kind of aid is a problem from the Establishment Clause. Now, Maggie, we're going to turn to you. Americans United for Separation of Church and State is known for opposing direct government aid to religion. So I understand from reading things on your website that DAU does have some objections, but if you can briefly highlight the key constitutional concerns that Americans United has.
Sure. So let me start by just saying that we definitely recognize that this is a hard time for a lot of people, that people are being hit financially, houses of worship are being hit financially. They have the same worries as many organizations about paying their staff and keeping their houses of worship going. At the same time, the nation's built on fundamental principles of religious freedom, and it's these that actually protect people of faith and houses of worship as much as they protect the non-religious and secular institutions. And even in hard times, we believe you have to adhere to the Constitution and the principles of church-state separation. There are many ways where houses of worship can get reimbursements, loans, things like that from the government. For instance, if they perform secular social services, they can get reimbursements for those services. Under the Paycheck Protection Act, they can get loans to pay their employees. That is something that they pay back. That is something that we are okay with. Our main concern is when they get loan forgiveness. So under Trinity Lutheran, it does say that you cannot turn away an institution because of their religious character. That is correct. It does not, however, say that that means you have to fund their religious uses of money, right? So they made the distinction between you can't deny Trinity Lutheran a grant for playground resurfaces because of who they are, but that doesn't mean that you can't put restrictions on what they do with the money. And so our concern here is that these grants, essentially loan forgiveness would be really a grant, would be going to fund paychecks and salaries for people who perform fundamentally, explicitly religious activities, in particular clergy. And when you think about the Establishment Clause and where it came from predominantly a very clear concern about the government paying for clergy salaries. It was about not being able to force the taxpayer to fund religious education, to fund ministers, and that's exactly what this does. And I know that it's people are just like with the mass gathering restrictions. People are sort of scrambling to find the answer, and we're short of time, and you need to get the money out. But I think that this is a real concern. And oftentimes we will see something like this put in place, and then it ends up being repeated in the future. So the next time there is a crisis, they'll say, well, we did it this time, it should be fine this next time. And so those are our primary concerns.
Well, speaking of next time there's a crisis, there have been crises in the past. Richard Fulton, we're going to turn to you to put this current bailout, if you want to call it that, in context with a variety of other types of generally available government benefits that clergy in particular and churches have benefited from, including emergency circumstances. And I guess specifically, if you could weigh in, is this more like the elimination of clergy salaries in colonial days as the non-establishment principle took hold, or is it more like paying the salaries of military chaplains and chaplains at state legislatures?
I would say it's like neither. I mean, the chaplaincy is a special case in our governmental structure, which I think builds more on the idea that soldiers and prisoners, not to make any comparison between the two, but in both cases, you've got folks that are away from civilian institutions, and the way for them to engage in the free exercise religion, it's not feasible to do that unless you have people on staff and present able to provide those services. So I want to put that case aside. And, I also want to put aside the issue of what does Trinity Lutheran mean. That's, of course, as Maggie has said, the case where the court upheld eligibility for funding to rebuild a playground or a park. I forget what it was. I think it's a playground, maybe parking lot. For funds that were, not going to be used for a quote unquote religious purpose, even though they were part of a religious institution. Whether it will be limited in the way Maggie suggests, which is to say, the character of the religious institution doesn't matter, but what you use the funds for does. I actually hope it will be limited in that way, but with the current Supreme Court. But I think what this case is really more like is an exception in terms of funding restrictions that has grown up over the last 10 years or so, which I call, I'm not sure anybody else does, but what I call the social insurance exception. What does that mean? It means there are certain situations where funding is made available to religious institutions because there's a social issue that's widespread, where there's not really, the government is really not acting in a discretionary fashion, so you don't have the moral hazard of the risk that the government is going to be preferring religious institutions or particular religious institutions of others. And at the same time, there's a public health need or public emergency need to treat those religious institutions the same as secular institutions. And the two examples of that are the nonprofit security grants that in the wake of terrorist attacks in the United States were made available to houses of worship along with other nonprofit institutions so that their infrastructure could be bolstered to enable them to protect their congregants, their members of the public, against violent attacks of violence, just as those funds would be made available to other nonprofits. And to be sure, I'm in the community that's concerned about separation of church and state and that wants strict separation, there were divisions on that issue as to whether or not those funds should go under those circumstances to religious institutions, with some folks, saying, we understand that we want to keep people safe, but for all the reasons Maggie has discussed, we think there's a moral hazard, there's a danger, there's a threat to establishment, concerns about not putting money into pockets of house of worship to not allow that funding to flow, and they're just going to have to find their security funding somewhere else. A similar kind of case, although even more of a social insurance situation, has been in the wake of some recent natural disasters, Katrina and Sandy, where funds began to flow to houses of worship. Originally, they were being denied that funds, and then the funds began to flow to them so that they could repair and rehabilitate in the wake of a natural disaster, just the same as other eligible institutions, nonprofits and others. They were eligible for the funds. And I think that this case we're talking about here is a lot like those cases, that we're all at risk. All of these religious institutions are suffering the same way other nonprofits are, which are suffering the same way for-profit institutions are. And there already was a big change for nonprofits to be eligible for this kind of funding in the first place. And we have to be able to say, I think, and I'm speaking only for myself, but I think we have to say that's a different kind of situation. And in principle, there's not that much difference between lending them money and then making them pay it back, which may be an enormous difficulty for those institutions to do, and saying you're going to be subject to the same forgiveness structures as everybody else. And I understand the concern that principle not be applied to normalcy, and those of us that care about separation of church and state and guarding against money from the public treasury normally going into the treasury of a house of worship are going to have to be vigilant in preventing that from happening and arguing against it and saying this is something different. But I think it is something different, and I think the complexities and the entanglement that will go with trying to get that money back when it's not happening with other nonprofit institutions is just as much of a problem in terms of separation of church and state, not as much. There's also a problem in terms of separation of church and state. So given these precedents, I would say this is the kind of situation where I don't think there's a significant constitutional problem with the funds going to houses of worship under these circumstances. The fact that it's under these circumstances doesn't mean that it's something that's going to apply to all circumstances in the future.
So Rama, let's turn to you next. I'm guessing that I'm probably not alone in being pretty clueless as to where the Islamic community stands on issues of separation of church and state or separation of mosque and state and the issue of government funding. Are mosques going to object, or are they, do you know if they have started participating in any of these programs?
I think that one thing that to put forth to begin with is that the masjids aren't under any one large umbrella. So there is not any monolith to Muslims around the United States. So there is no one big group that has said, this is, the ruling and everyone must follow it. I really think that it's going to be very specific to individual congregations. And really it's going to come down to whether or not they have participated in other government funding and grant programs. So, I know of masjids and Muslim religious organizations that have already taken money from the government in grant programs and other type of grant programs, such as CVE, countering violent extremism. There's one population of masjids that will definitely take money on CVE. There's another group that will never take any money from the government for CVEs. And then for Muslims, another thing that has come up really, so the Paycheck Protection Program is attractive because it's a grant program. The loan program is not attractive because of interest. And so there are a lot of Muslims who will not take a loan because of the interest attached to it, because they feel that under their religious conviction, they should not be taking interest. So I think that for Muslims, I think that the Paycheck Protection Program, with the basically turning it into a grant if you keep the level of employees through June 30th, is going to be what they usually go through instead of going through the other ones that are loans. Even if it's at a very low interest rate, it's still an interest rate. It's still a loan there. And so I think a lot of Muslim organizations are going to stay away from that one just because there's interest involved in it.
As a litigator, I'm familiar with that teaching of the Islamic faith because I've encountered it with my clients. But it probably a lot of folks are not aware that Islam really has a very strong prohibition on interest. Now, there were questions asked, and I'm going to address it here, about whether there have been other types of programs where pastors specifically benefit from government funds. And I think that there are a number of things like the Earned Income Tax Credit or unemployment benefits, food stamps. Two that are particularly significant are the parsonage exclusion, which is a big tax benefit for clergy. And then for teachers in religious schools, they get a wonderful benefit. The tuition subsidies that they get for their kids are tax-free. So there are definitely a variety of salary type or salary related benefits that clergy and others working for churches do get to benefit from. So this is perhaps somewhat different, but it's there is a continuum here. I think before we turn to more of our audience questions, I wanted to put out generally to the panel, if you have some practical advice for groups that that are considering whether to apply for funds, are there some things that you think that groups should be thinking about if they're going to apply?
Well, I can start if it's, oh, go ahead, Rama. No, go ahead.
Well, I would just say that just be clear that the government wants a lot of information. So if you don't want the government to know about, you know, all of your payroll and how it works out, then you shouldn't apply. There's not just giving you money. You just don't go to the bank and say, hey, I'm this mashed. I have a payroll of $20,000. Give me $20,000. Every bank, and I've looked at several of them, are asking for a lot of information. If you do not want to give the banks that kind of information, don't apply. But do know that once you apply, they have that information. So I usually tell people, if you have an issue with people knowing all your information, don't apply. Just don't, because don't come to me later saying, how dare they know how much, you know, our pastor makes that we weren't going to tell him, and our imam didn't really disclose how much. You applied. Once you get into the game, you have to follow the rules. So once you decide to get in the game, follow the rules. And that's my recommendation I give to people, is that if you decide to get in the game, you have to follow the rules. Well
said. Mark, I think.
No, she said it better than I was going to say, because now you're going to hear me say it worse than she said it. Is that certainly if you get in the game, you have to follow the rules, and that's with the banks. But a long-time church state figure of note, the Reverend Dean Kelly, the late Dean Kelly, used to say all the time, with the king's coin comes the king. And so for a number of religious organizations that are not used to following all of the rules that come with federal financial assistance, this is federal financial assistance, at least for the duration of the program and the duration of your participation in it. So you have to read the fine print, and you have to understand what you're undertaking. And just as Rama said, you know, you may not want the banks to know all of this stuff. You may not also want to have to comply with the federal requirements, and if that triggers state requirements on the receipt of public money. So all of those things have to be considered as part of this. And I guess the last practical tip that I would have is make sure it's the other side of the coin that Rama said, which is make sure that you know what you're applying for, and that you have the wherewithal to be able to administer the program. There are a number of people that I think are frightened, especially smaller places and smaller charities are really frightened that this is going to be something which is going to sink their ability to perform in the public. And they don't understand all of these things. They're about feeding the hungry and sheltering the homeless. And they haven't really thought this all the way through. But you need to just step back from it, and not just what are you going to tell the banks and what are you going to be subject to the government, but are you going to be able to manage this commitment? And if you can't, you know, what's going to happen? So those are between us 3 practical tips.
Anyone else?
I would say it even worse than either Mark or Rama. So I absolutely agree. Even if I think it's permissible, doesn't mean that it's necessarily the wise thing to do for an institution, is to take those funds. And I just wanted also to make the observation that you can tell which of us have been doing this for a long time by the fact that we all like to quote Dean Kelly, because I just quoted that same adage of his in another program last week. Dean Kelly was one of the great wise men of church-state separation, and it's good that we're keeping his memory alive.
I would say amen to that. Well, one of the audience questions says, forgive if this has already been addressed, but on what basis are municipalities able to fine and shut down drive-in services where congregants stay in their vehicles and no such gathering is prohibited in the state's order? Well, first of all, I need to point out that that's not what was going on in Kentucky. The city of Louisville clarified a little late perhaps that they did not intend to fine and shut down. But with that caveat, would someone like to address whether municipalities or under what circumstances they can fine and shut down drive-in services?
I think it goes back to what some of us were talking about at the beginning, the issue of equal treatment. I think the point that has made has been, if you can go into a drive-in at a Sonic, I mean, I barely know what a Sonic is, but that if you can have a drive-in service at a Sonic, I mean, service in terms of getting your hamburgers or whatever it is they happen to sell, that you ought to really tread carefully in terms of telling folks that they can't have a drive-in religious service where nobody gets out of the car, where there's nothing going on that's inconsistent with social distancing or putting other people in danger. That's a big issue. So I think you're right, Alan, to point out that there's a real question whether or not that mayor actually ever really did shut down the drive-throughs, as opposed to a judge who seemed to be anxious to be able to write an opinion that didn't look to the fact so much as wanting to, in effect, make a job application to be elevated to the appeals court. But yeah, it's really a question of, what are the standards, and is there equal treatment going on, and is there really an objective reason why those drive-in religious services are problematic in terms of public health? Without being able to demonstrate that, there's really no reason why they shouldn't go forward.
Yeah, and can I jump in?
Yes.
One thing also to understand is sometimes the state executive orders are granted in such a way that they are allowing the local governments to add upon that. Like in Georgia, for instance, Governor Kemp has said, here's what I'm saying. Local governments can sort of look at their circumstances, look at their having clusters, and add more restrictions if they think it's necessary. There are then states like Florida, where DeSantis is saying, here's my floor, and I'm going to prohibit anyone from being more strict, whether it is you're seeing people having spring break parties on the beach, but you can't do anything about it because I'm not putting a mass restriction in there. So that's, I think, one thing to understand, that it depends on the state whether or not the locals can do more. And then the other thing I just sort of want to add to, as you're looking at whether or not things are being treated equally, which I think is really important, but also to look at how those other places are working. Like, for instance, in the Kansas argument, one side was arguing, well, it's not fair because it's not fair to say that there can be no mass gatherings at churches because you can have 10 people at a restaurant. And the governor's council was explaining how it sort of works differently, right? Like in a restaurant in Kansas, you can go to pick up your food, you can walk in, there was allowed to be someone behind the counter and someone at the door or whatever to make sure people don't come in and it's not crowded. So they could have 10 people, 11 people there because they're sort of coming in and leaving. Whereas at a mass gathering at a church, it would be people coming, staying in one big room, and sort of explaining some of the differences about how different organizations and businesses have to work. So I think that as we're talking about this, we sort of have to think also about the way that these entities work and how it would function. So it's, sometimes you might want to treat the restaurant differently, or, people need to eat, those sorts of things. You need to sort of think about the context and the safety reasons and whether or not it is meeting your main goal, which is to not spread the virus.
Well, I want to return then to a question. Maybe we answered it, but maybe we didn't adequately answer it. The questions that I get from pastors are, if the liquor stores and the Costco's are allowed to open, why are churches somehow less essential? You know, we feel we provide essential spiritual and emotional care for people. Why is that not a problem of equal treatment, that churches are not treated the same as some of these other entities? Anyone want to address it?
Yeah, well, again, it comes back to what are the standards applicable to that store where they're, and Maggie was alluding to this as well just now. You have just a few people are allowed in. They may be there only for a limited period of time, and then they exit. And I don't think I don't think in any of these places are restaurants open for people to come in and sit down any longer and have a meal. I mean, if that's going in and somewhere in the country right now, it's definitely an outlier in terms of what the practice is. In that respect, it's a restaurant where people would come in and sit down would be maybe more similar to what's going on in a house of worship. That being said, I do agree with the notion that it's a problem to say that to the extent houses of worship are able to operate in accordance with the strictures on gathering and on length of time on the premises, and in order to enable, for instance, closed circuit Zoom programs to be set up where perhaps a clergy is in a pulpit and delivering a sermon or leading a service where folks are on Zoom. That has to be able to happen, and that's no less an essential business than these other things that are being treated as essential businesses. So I agree with the listener that we shouldn't be we shouldn't be thinking of houses of worship, of religious institutions, as non-essential businesses. What we should be thinking about is how can they operate as an essential business in a way that's consistent with public health and safety concerns. And to the extent they can do that, that's fine. And to the extent they can't do that, this is not one of those cases where they should be treated differently than secular institutions because of the great work.
And this is the point we made earlier, Alan, as I agree with Richard that one of the points we made earlier was that this is really poor optics on the part of politicians. Because first of all, they're treating houses of worship as businesses, so it should be their first clue that they have a political issue. And the second clue should be that they're calling them non-essential. That there is a role to play, and certainly for believers, this is an important, vital, perhaps the most granular role, is to provide stability and strength in times of trouble. And you just have to figure out a way to do this consistent with the best public health practices.
So,
Go ahead.
Sorry. I think most of the executive orders are actually treating them as essential businesses. They're just not exempting them from the mass gathering exemptions, right? So I think when people are talking about them, they're not talking about them as I'm still allowed to go to my church for the funeral with a small gathering or for the video conferencing. They are comparing sort of the oranges and apples, right? They're saying, you're allowing this essential business with under 10 people, therefore you have to allow my mass gathering of 500 people, rather than saying no one is allowed to have 500 people. My house of worship is treated the same as an essential business, and that means we cannot have a mass gathering like they can't. So I think it's sort of, and I don't blame the media for this or whatever, it's a confusing issue, and executive orders are coming out every single day that are confusing. You've got to piece them together, but I do think that most are being treated as essential services.
Well, we have a question on a different topic about religious liberty implications for inmates from a gentleman who serves as a religious liberty director of a Seventh-day Adventist church and as a pro bono federal defender for an inmate who has not seen a clergyman for over 5 years in jail. And he's asking, are there any special accommodations for early release? I'm not sure if any are interested in trying to address that.
I don't think it's about getting special treatment for somebody on religious issues. The problem of getting prisoners out of a setting where the virus can spread rapidly, where these can be prisons can be in our clusters for for the disease to spread. And folks are not in jail to be, it's not supposed to be a death sentence to be sent to prison. And I know there's been other ABA programming, Civil Rights and Social Justice Section programming on the issue of obtaining release of prisoners so that they can get out of these environments. And of course, we have to deal with the concern about folks that are dangerous, that may be dangerous to members of the public once they leave, and how do you deal with those particular individuals. But as a rule, we ought to be thinking of what we can do to get people out of these dangerous circumstances, both the prisoners and the people who guard them and care for them, because of the danger that the disease is going to be spreading in those very tight quarters. So that's the general issue, and I don't think anybody, any particular prisoner should be treated differently because of their faith, but we should have a concern about their physical well-being, every single one of them, to the extent they're placed in danger given the circumstances of the way a prison operates.
Well, I appreciate your putting in that plug for the other program, and Ollie just posted it to us with information about the other ABA program about prisoner issues. Looking at the clock, it's pretty much wrap-up time. Anyone have any closing thoughts? Rama, let's start with you and go around the circle.
Well, my closing thought would be the same one that I've been giving everyone that I really interact with. At this time, as a faith community, we need to rely on our faith and really focus on the blessings. I think that a lot of people are concerned about their jobs and just so many different issues, and some of us are neglecting our mental health. And I want a lot of people to really focus on the blessings that we have right now, the fact that we even have the opportunity to talk about religious freedom and to even question whether or not we have this right to go to our religious spaces as a benefit and a blessing, and to really focus on the blessings instead of the negatives. I think that that's one thing I want to really stress. I teach at law school, and I tell the law students, you will get over this, you will overcome. This is just a short period of time. So please really focus on your mental health and really focus on this is happening to all of us, and we're all going to get through this together.
On that theme, Rama, I posted a news article that China is restricting the live streaming. The churches are not allowed to live stream. And that really puts in perspective what we enjoy here in the US. And I think, there will be a time if the restrictions go on too long or are too severe and the virus has subsided, there will be a time to raise significant First Amendment concerns. Right now, I think our primary concern is just getting through, knocking the socks off the virus and dealing with public health. But let's go. I'm just looking across how you speakers are appearing on my screen. So Maggie, we're going to go to your smiling face next.
Let's see. I feel like I've talked so much, I'm not really sure how to end it. I guess, speaking of the mass gathering provisions, it's not just a matter of constitutional issues, which are obviously very important to me and to everyone, but a lot of these are a matter of life and death. There are lots of stories across the country of there being clusters of the coronavirus that are started at churches. And I mean, it could be a church or a synagogue or anywhere. It's just as likely as a secular gathering. And so it is the responsibility, I think, of everyone to think not just about themselves, but about other people. So by having these gatherings, you are putting at risk your fellow parishioners, as well as anyone they come in contact with and anyone that next person comes in contact with. And so it really is dangerous. And so I think I'll just leave it at that.
Mark?
This is a time, I think, when people need to look within as well as to look without. And when they look within, at least some of the people who are attracted to this webinar are people of faith, for whom this is really, as I said before, not only an important question, but likely the most important part of who they are. It's part of their identity, and it's part of why they get up in the morning, why they do what they do. And these are really challenging times. And these are times when we need to find a way to facilitate the role of religion in the lives of Americans. I think the things that we talked about today illustrate some of the challenges with that, and how to balance our responsibility with responsibility for the common good. But at the end of this, you know, as people of faith and as people who believe, we believe that this will indeed pass, and that it's our responsibility to bring everyone to the other side with us.
I'm just now seeing a question that I was not able to see earlier. I'm going to address it very briefly. What about religious institutions that provide secular medical services, such as Samaritan's Purse, that discriminate against other vulnerable populations, such as the LGBT population, purportedly on the basis of religion? Kind of remember how the Paycheck Protection Act, I know it does carry a non-discrimination clause, but of course federal law does not prohibit discrimination generally against the LGBT community. So I'm not sure how these programs would apply to this kind of practice. Richard, we're going to finish up with you anyway in closing comments.
I don't have an answer to that question either, but I'm not going to answer it.
Okay.
So just a couple of things. You know, as we look forward to the day, God willing, when we all emerge from under this shadow, I am concerned about, because there are folks that have been overreaching in terms of what they think they're entitled to in terms of religious accommodation, exemption, and placing others in danger in doing so. I'm concerned about two things. One is that the issue of obtaining religious accommodations from generally applicable rules already is a fraught one, which has given rise to, you know, all kinds of very substantial disagreements in our society. And I'm concerned that religious accommodation will get a bad name, even worse than it already has in some quarters, undeservedly so, I think so. But nevertheless, that's out there. So I'm hoping that at the very least, you know, when we're done with all of this, we'll at least be at the status quo ante, we'll be where we started, and we won't have the issue of respecting those who of a different faith and who need an accommodation from, you know, the general rules of society to observe their faith, that they'll be at least as well able to obtain those accommodations as they were before this all started, and that we don't regress in terms of the understanding that if we're going to have a diverse and tolerant society, it includes respecting and tolerating those who don't necessarily move to the same drummer as everybody else on things that are important, you know, on all sides of the political spectrum. So that's one issue. The other, but it relates to the same thing, is the issue of stigmatization and the singling out of populations that are somehow held responsible for the spread of the virus. Earlier today, this section had a program on threats to democracy, including a singling out of Asian Americans, which we know is its own pandemic at the moment in terms of attacks on Asian Americans, and both verbally and also physically. And similarly, there's been some anti-Semitic stuff. There have been other things directed at religious communities that are somehow held responsible for the clusters that are taking place. And the fact that there is a particular segment of some population that's behaving that way and that's not closing their churches or synagogues when they ought to, should not be a basis to stigmatize and single out or stereotype any one community. We have to deal with individuals or even particular congregations that are behaving badly, and they need to, you know, they need to be shut down if that's necessary. But that's not the same thing as you know, as again stigmatizing those people who are observant any more than it's a basis for stigmatizing members of a particular ethnic group. So we need to be concerned about and guard against that, and we need to stand with each other when any one of our communities is subject to this kind of singling out. And the last thing I want to say is I saw in recent days a fascinating picture. It was a picture during 1942 or so in one of the ghettos that had been created by by the Nazis during the Passover season. And by the way, we're still in Passover now. We're just done Seders. And it was a picture of several men underground, literally underground, where they were baking matzah so they could observe the Passover holiday. And they were smiling under the most dreadful circumstances that, God willing, none of us will ever have any idea of what kind of circumstance they were living. Nevertheless, they found a way to observe their faith, to act in solidarity. And so we in the Jewish community and others in other communities are continuing with trepidation, but nevertheless continuing to be true to our observances. And also, we all, and just to pick up on the point Rama made, we also have to act in faith that this too shall pass, and they will emerge on the other side, and our lives will continue, and hopefully we'll be able to move back into having the normal kinds of arguments and discussions and issues we all have to deal with, and not be dealing with these extreme circumstances for very much longer, God willing.
Well, I want to thank all of our panelists. I think, and I also want to thank our participants and all 123 who stayed to the end. I think we were numbering about 200 at one point, was the largest number that I saw. These are challenging issues. And even those of us who've been thinking about church-state issues for a long time, it's a challenge. So again, you all who registered will be sent a recording of the program. Hope you like it well enough to think it worth sharing. And thank you very much. All have a great day.